In a legal description, the terms lot and block relate to A. Correction lines and datum plane. B. A meets and bounds description. C. The government survey system. Or D. A recorded subdivision map. The answer is D. A recorded subdivision map. Lots and blocks are found in subdivisions. They are platted or mapped. A property owner wants to use water from a river that runs through the property to irrigate a potato field. To do so, the owner is required to submit a permit request describing the beneficial use plan for the water. If the owner receives a permit, it can be assumed that this property owner's state relies on which rule of law? A. Doctrine of prior appropriation. B. Doctrine of highest and best use. C. Common law littoral rights. Or D. Common law riparian rights. The answer is A. Doctrine of prior appropriation. In many states where water is relatively in short supply, statutes have passed authorizing a system of prior appropriation in which owners downstream do not necessarily have to wait for what's left after those upstream have drawn their fill. Priority, who gets to appropriate water first, is instead established by date of approved filing and continued conformity with any rules and limitations on use imposed by the jurisdiction. A description that states, start at the street sign at the corner of Ash and 11th. Go 100 feet south, then 50 feet west, is most likely what type of legal description? A. Urban. B. Government survey. C. Lot and block. Or D. Meets and bounds. The answer is meets and bounds. D. Meets and bounds descriptions use starting points and read in a clockwise direction. A seller commits fraud to convince the buyer to purchase. The contract is now considered A. Illegal. B. Void. C. Voidable by the seller. Or D. Voidable by the buyer. Shit, I didn't put the answer. It's not B though. It's not void. Oh wait, yeah I did. The answer is D. Voidable by the buyer. Only the deceived or potentially injured person has the right to terminate the contract. New home warranties cover everything except A, structural damage, B, material failures, C, poor workmanship, or D, faulty appliances? The answer is A, structural damage. Structural damage, which is created by outside forces, is not covered, while structural defects from poor workmanship or material failing would be covered. What is a bill of sale used to transfer the ownership of? A, real property, B, appurtenances, C, fixtures, or D, personal property? The answer is D, personal property. Personal property is conveyed by a bill of sale, while real property is conveyed by a deed. A buyer and seller have entered into a binding contract for the sale of real estate. What type of title is held by the buyer? A, executory, B, legal, C, none of these, or D, equitable? The answer is D, equitable. The buyer has equitable title, which recognizes that he has an interest but has not received legal title. Legal title will pass at closing when the seller gives the buyer the deed. A homeowner applies to the municipality for permission to open an adult daycare facility in his neighborhood. What may he be granted that would allow him to do this? A, amendment to the zoning ordinance, B, conditional use permit, C, non-conforming use permit, or D, variance? The answer is B, conditional use permit. A conditional use permit is usually granted to a property owner to allow a special use of property that is defined as an allowable conditional use with that zone. Which of the following is an example of involuntary alienation? A, deed, B, police power, C, blockbusting, or D, adverse possession? The answer is D, adverse possession. Involuntary alienation means a property owner is forced to give ownership to all or a portion of the property involuntarily, or of the answer choices, only adverse possession represents such a case when another individual meets the adverse possession criteria for the required length of time. How are the length and terms of a home warranty for a resale property determined? A, contract, B, state law, C, negotiation between the seller and the company, or D, federal law? The answer is contract, A. The terms of home warranties are created by contract. Which is an example of constructive eviction? A, a tenant who moves because the unit no longer has water. B, a tenant who moves out because he doesn't like the neighborhood. C, a tenant who receives a notice to quit or pay rent. Or D, a tenant who remains in possession after termination of the lease. The answer is A, a tenant who moves because the unit no longer has water. When conditions cause a rental unit to no longer be habitable, the renter has constructive eviction. Without water, a tenant is unable to bathe, cook, wash clothes, and so on. The tenant must leave, not just withhold rent. Under the common laws of agency, in a typical agency relationship between a broker and client, the broker's commission is determined by A, the top 3 office producers, B, the local realtor association, C, the Sherman Antitrust Act, or D, advanced negotiations. The answer is D, advanced negotiations. A broker and client negotiate and determine what commission schedule will apply to the transaction. Commissions are always negotiable. Which is an example of liquidated damages for breaching a real property purchase contract? A, a court action for specific performance. B, damages for taking private land for public use. C, the forfeiture of earnest money deposit. Or D, recovery of money lost as a result of the breach. The answer is C, the forfeiture of the earnest money deposit. If a buyer provides earnest money, it is often identified in the contract as predetermined liquidated damages and is the seller's remedy if the buyer defaults. The death of a party would terminate which of the following contracts? A, option to purchase. B, land contract. C, exclusive right to sell listing agreement. Or D, purchase contract. The answer is C, exclusive right to sell listing agreement. Personal service contracts depend upon specific individuals, so the death of one party would cancel the contract. The listing would terminate if the seller dies. The estate would take over the property, or if a sole proprietor listing broker dies. When parties own property as tenants in common, each owner A, must have equal undivided interest. B, must have acquired rights simultaneously with the other owners. C, has ownership of no specific part of the property. Or D, has the right to survivorship. The answer is C, has ownership of no specific part of the property. Tenants in common have an undivided interest in the entire property. Survivorship and unity of time and title apply to joint tenants. In a contract to purchase real property, Which is the clause that allows the buyer to cancel the agreement to purchase if the buyer cannot obtain sufficient financing? A. Release clause. B. Contingency clause. C. Due on sale clause. Or D. Alienation clause. The answer is B. Contingency clause. This would be the financing contingency. Clauses that allow the contract to be canceled if an event happens or does not happen are called contingency clauses. Zoning ordinances normally define specific uses for land that are permitted with a municipality. All of the following are designated uses in such ordinances except A. Industrial, B. Rental, C. Residential, or D. Commercial. The answer is B. Rental. Zoning ordinances have traditionally classified land use into residential, commercial, industrial, and agricultural classifications, but do not include rental. An example of specific performance for breaching a real property purchase contract is A. The forfeiture of the earnest money deposit. B. Damages for the taking of private land for public use. C. A court action to force compliance with the contract. Or D. Recovery of money list as a result of the breach. The answer is C. A court action to force compliance with the contract. Specific performance is a legal remedy in which a court orders someone who has breached a contract to actually perform the contract as agreed, rather than simply paying monetary damages to the other party. How does a tenancy in common differ from a joint tenancy? A. Tenants in common must acquire their interests at the same time. B. Tenants in common must have unequal interests. C. Tenants in common must have equal interests. Or D. There is a survivorship right if a tenant in common dies without a will. The answer is B. Tenants in common may have unequal interests. Tenancy in common is the only form of ownership that can have fractional, unequal shares of ownership. At the end of a life estate, the holder of the remainder estate has what type of estate? A. Life estate. B. Qualified fee. C. Fee simple absolute. Or D. Remainder estate. The answer is C. Fee simple absolute. Once the life tenant dies, the person holding either the remainder estate or the reversionary interest will have all of the other rights restored to the holder's control. Controlling the entire bundle of rights is fee simple absolute. The tenant who remains in possession after the lease expires. A. Is on periodic tenancy. B. Has a life estate. C. Is a tenant at sufferance. Or D. Has a servient tenement. The answer is C, is a tenant at sufferance. One way to remember this term is that when tenants stay past their lease expiration date and refuse to pay rent, the landlord suffers. What is the purchase contract provision that states that the buyer will forfeit his deposit if he fails to complete the purchase? A, liquidated damages. B, subordination clause. C, safety clause. Or D, punitive damages. The answer is A, liquidated damages. If the buyer defaults, the seller can either sue specific performance or keep the earnest money, liquidated damages. Buyers always receive specific performance because they didn't have anything from the seller to liquidate. The listing broker and seller find a small roof leak in the attic. Because the property is being sold as is, A, the seller and broker both must disclose this material fact. B, the seller and broker should have the buyer talk to the seller because the seller is not required to disclose it. C, if the buyer's inspector finds a problem, the seller does not have to disclose it. Or D, the seller and broker do not have anything to disclose anything. The answer is A, the seller and broker both must disclose this material fact. All material facts must be disclosed by both the seller and broker, even if the property is being sold as is. Which type of deed provides the best protection for the buyer? A, special warranty deed. B, general warranty deed. C, grant deed. Or D, quitclaim deed. The answer is B, general warranty deed. The general warranty deed has the most promises. Upon the death of a life tenant, the holder of the remainder estate will have which type of estate? A, fee simple absolute estate. B, estate for years. C, life estate. Or D, estate at will. The answer is A, fee simple absolute estate. Upon the death of the life tenant, the estate either returns to the grantor / reversionary interest or goes to the remainder man. In either case, the estate will be fee simple absolute. How are parking spaces in multi-unit buildings, water rights, and similar things of value classified? A, appurtenances. B, trade fixtures. C, covenants. Or D, emblements. The answer is A, appurtenances. Appurtenances are rights or privileges associated with the property, although not necessarily part of the property. What is a contract that is yet to be performed? A, executory. B, unilateral. C, unenforceable. Or D, void. The answer is A, executory. The period from when the contract is agreed to and signed by both parties until it is executed is called the executory period. A deed conveying land to two parties on 1/3 and 2/3 share basis establishes A. Long-term lease, B. Tenancy in common, C. Joint tenancy, or D. Tenancy by the entirety. The answer is B. Tenancy in common. Only tenants in common can have unequal shares of ownership. Which is an example of voluntary alienation? A. Escheat, B. Deed, C. Eminent domain, or D. Lease. The answer is B. Deed. Voluntary alienation means the property was freely given. In a deed, the grantor willingly transfers the title to the grantee. Escheat and eminent domain are examples of involuntary alienation. Leasing is not the transfer of property, only possession. A broker who has done proper CMA discusses the probable market value of the property with the seller, but the seller wants to list the property for an unrealistic price. The broker may do all of the following except A. Suggest the seller have a formal appraisal done, B. Take the listing at the proposed seller's price, planning on reducing the price in the future when the seller is more realistic, C. Take the listing with the understanding that price reductions may be needed, or D. Decline to take the listing at the high price. The answer is B. Take the listing at the proposed seller's price, planning on reducing the price in the future when the seller is more realistic. Whether a CMA or a formal appraisal is used, the figure sought is the property's market value, and while it is the property owner's privilege to set whatever listing price the owner chooses, a broker should consider rejecting any listing that is severely out of line. A broker who has done a proper CMA discusses the okay, I already did that. Take the listing at the proposed seller's price. Okay, a couple is buying a house together. He wants his children from a previous marriage to inherit his share of the property. The couple should hold title as A. Tenants in severalty, B. Tenants by the entirety, C. Joint tenants, or D. Tenants in common. The answer is D. Tenants in common. Because he wants his ownership to pass down to his children, they should take title as tenants in common, and he should write a will for the property to pass to his children. What is the form of ownership that does not require probate to transfer title? A. Tenants in common. B. Severalty. C. Joint tenancy. Or D. Tenants by the entirety. The answer is C. Joint tenancy. Joint tenancy with the right of survivorship means that if one owner dies, the owner's share will automatically transfer to all of the other owners. The owners that are left will have to file a joint tenancy affidavit to clear title, but will not go through probate.